we are comfortable in going first.
चलें फिर आप शुरू कर लें.
Before Makhdoom Saab starts, I'm seeking permission to withdraw as amicus as I've been engaged by the other two grandchildren of the late Zulfikar Ali Bhutto Saab.
Who are they? Can you name them, please?
Fatima Bhutto and Zulfikar Bhutto.
Okay, fine.
We were appointed a
Does anyone have any objection?
before.
He wants to come that side.
I think it's very good. It's
No objection?
No objections.
And I filed my CM.
To point out at the outset, my wife is the granddaughter of Nawab Ahmad Khan Kasuri. So if anyone has any objection.
Do you have any objection?
I have no problem.
More important, does your wife have any objection?
She does not either, sir.
So we'll ask.
I thought I should point it out.
Does anyone have any objection? He's made disclosure. Farooq Saab? वो तो उनकी ग्रैंड डॉटर है ना. आपको कोई ऑब्जेक्शन है?
Then let me ask my.
पूछें. रजा रबानी साहब, कसूरी साहब, किसी को ऑब्जेक्शन है बता दें. सलाउद्दीन साहब ने has made disclosure and his wife has no objection, which is the most important. So the complainant would be her uncle.
Yes, my lord.
Paternal, maternal? Paternal uncle.
Any objection?
Okay, without knowing what he's saying, that is the confidence. So we chose wisely.
I'm grateful tonight, sir.
चलें ठीक है.
I
Okay.
knew his father very well. He was a friend of mine.
चलें कौन आएगा पहले? Mr. Makhdoom Ali Khan, would you like to start?
Lord, may I just make one submission since the question of disclosures?
Acha, you are for the criminal side of the matter.
Yes, I'm just making a submission.
You are also making a disclosure.
A disclosure.
Ji.
My Lord, Masood Mahmood was proceeded initially for contempt of court. Before he made his statement in this particular case as an approver, he was being proceeded for contempt of court in another case. And my father was representing him in that particular matter. I just wanted this to be brought to the notice of this honorable court.
Do you have any objection to be amicus yourself?
No, I don't have. I know what I have to say.
Okay, same applies. Anyone has any objection? Disclosure has been made. If anyone has objection, please say so. Otherwise, we take it no one has objection. So no one is objecting to you, Khwaja Sahab. Your fairness has acknowledged.
I'm grateful.
Yeah. जी, आजे कौन आ रहा है? मखदूम साहब. जी. My Lord, have you filed anything? First of all.
My Lord, we had prepared it last time round. I was
Now is anything filed before us?
My Lord, we had filed certain bundles when the other bench was hearing the cases. It was a differently constituted bench at that time. I am hoping and presuming that they are still available.
Do you have some number of that or anything like that?
We will file them again, my Lord, during the course of the day.
Or just give us the number. We can a lot of documents to find it.
They were not filed in the form of
concise
CMA.
statement.
They were formed in the file of concise statements together with case law and supporting material in that respect. And they were bundles.
You don't mind
spiral bound.
But it may have got misplaced.
My Lord, we'll file them again. We have got sets prepared and we'll file them again.
Thank you. Ji.
My Lord, when we look at this reference, it has to be now examined in the light of the 4 questions which were framed by...
Can you first read the constitutional provision regarding presidential references?
Article 186 of the Constitution, my Lord.
Ji.
If at any time the President considers that it is desirable to obtain the opinion of the Supreme Court on any question of law which he considers of public importance, he may refer the question to the Supreme Court for consideration.
Can you read sub-article 2?
Yes, my lord. The Supreme Court shall consider a question so referred and report its opinion on the question to the President.
So the first and foremost question is, do we have an option to say we don't want to hear the reference?
My lord,
As per the language of Article 186.
as per the language of this article, your lordship do not. But as per your lordship's practice and jurisprudence, at times your lordships have refused to answer a question when your lordships have found that to be too vague.
But that would not be a refusal to answer the question.
Yes.
That would be inability to answer a question.
Yes.
So you consider the question, you may ask me a question which I don't know. I mean, how many stars are there in the galaxy, for instance? And I'll say, I don't know, but I have answered the question by saying, I don't know. So that's not an, so it's we are obliged to answer a question. We can come to the conclusion and say, we don't know. Okay.
That's it.
Could we also say that it says that we have to form an opinion on the question, and we could say that it's not a question.
My lord, sorry.
So we could, I mean, it says that report its opinion on the question to the President.
Yes, my lord.
So the question of law that's posed before us, we have to give an opinion. So one opinion could be that this is not a question of law.
That can be, my lord. Your lordship may say it is too vague for us to answer. It is not a question of law.
It would still constitute an opinion.
Your lordship can, even if your lordship comes to the conclusion.
But that response would also be an opinion.
That's an opinion.
Yes. And if your lordship comes to the question.
We have to respond.
That a question is not properly phrased, but the meaning is apparent to your lordships. Your lordships can rephrase or reformulate the question.
Which we have done.
Yes.
As we have to form an advice for the President.
My lord, this is in the nature of an advisory opinion, but according to your lordship's jurisprudence and jurisprudence from other courts, this is binding. It virtually stands in the same rank as a judgment of this honorable court. So such an advisory opinion would be binding on all concerned.
On question of law, not on the question of facts.
My lord, yes. My lord, in this particular case, the question of fact, which was the execution of the person concerned, is now a question or is now an issue which cannot be reversed by this honorable court, unfortunately. What is before this honorable court is an issue with regard to the jurisprudence of this honorable court and a stigma which is there for all times to come on the reputation of that person, and an issue whether the judgment or the conclusion was fairly reached. And it is.
You have to address on this point also the conviction recorded, appeal was dismissed, review was dismissed, and then this is a question of law that has been posed to us to answer. So in that regard also whether this can be done, because if it is done, this can be done in every case.
My lord, if your lordship approaches it from the constitutional perspective, this possibly cannot be done in any other case. If your lordship approaches it from the pure perspective of criminal law, it can possibly be done in every other case. So the question is, which is the perspective which your lordship will use? My lord, there is no other case, and it is perhaps for this reason that my lord the Chief Justice issued a direction to summon the actual transcript of one of the interviews of one of the learned judges. This perhaps is a unique case in the jurisprudence from common law jurisdictions, where a judge who was part of the narrowest of majorities has thereafter himself given an interview, much after he has retired, no doubt, where he said that the judgment was a result of quote-unquote pressure and was...
Basically, the reasons of this reference is the interview broadcast by the television. Justice Naseem Hassan Shah.
My lord, I am not privy to what formed the basis of the reason for this, because that only
He
the...
also called upon all the parties to submit the transcript of that
Yes, ma'am.
interview, and I think notice was also issued to Geo Television to submit the CD of that.
I should just clarify at this juncture that Director News of Geo has sent this sealed envelope, which I have not opened,
My lord.
which probably contains some sort of a hard disk, I think.
My lord.
Ek khol lein zara. So,
must be CD.
but you proceed as you want to, and if you want this to be shown or not shown, aap wo bhi bata dein, but some transcripts have also been attached. I have not had the time to go through them, but I think Raza Farooq Naik Saab
Transcript hai
has
ji.
filed transcript. फारूक नाइक साहब ने भी मेरे ख्याल में डिस्क लगाई है
USB.
यूएसबी भी है
तो
और
है,
डिस्क भी
वो
है
ट्रांसक्रिप्ट है आपका
या
रिकॉर्ड
मैंने
पे।
ट्रांसक्रिप्ट भी लगाई है,
वो
मैंने
बताना किस पेज
यूएसबी
पे?
भी दी है और
पहले एक अमाइकस को हम सुन लें फिर हम उस पे जाते हैं या यू वांट दैट टू बी हर्ड फॉर मिस्टर मखदूम अली खान हाउ वुड यू लाइक टू
My lord,
प्रोसीड
I would respectfully submit, because this is the key question in the reference, particularly with regard to the principle of nemo iudex. It will help us all, particularly the amici in this case, if this is formed in the form of a video disc, it is played, or if it is in the form of an audio disc, it is heard, so that at least we know.
ये हो सकता
No,
है
we can go through the transcript, and if we want to verify the validity and authenticity of the transcript, then we can play and we can see that interview whether the words have been properly transcripted or not. This is the way to see that.
My lord, it is not only your lordship, but it is also us, in order to make our submissions and to place them in a context that we need to know what is there.
My lord, may I-
अच्छा वो
may I
एक
make a
सेकंड
submission? May I
जब तक आप कंटिन्यू रखें वो टेक्निकल इश्यूज विल बी सॉल्व्ड इन द मीन टाइम
My lord,
सो प्लीज
may
प्रोसीड
I make a submission? I have attached with the CMA a lot of interviews, a lot of.
First, we will see what Geo has sent.
Okay.
Because the primary source was that. Then, if required, we'll also see yours. We are just seeing if we are just attending to the technical aspect. Let him continue.
Yes, there were also interviews given to various persons.
ठीक है. We will come to it, but let him continue.
I
We
will-
want to make progress.
Yeah, जी, जब मैं argue करूंगा, I will like to rely on them.
Yes,
Rely
yes.
on them.
We won't stop you. Don't worry. जी.
ये है जी, इसमें लगा हुआ है, I have opened the envelope of Geo TV, इसमें ट्रांसक्रिप्ट है लगा हुआ।
लेकिन हम कह रहे हैं सुना ठीक है
My lord, in this context, I'm not saying right now, but your lordship may also like to see, and because again Mr. Waqar Rana has written an article for the Business Recorder, but I don't go there, in a book published much before this reference in the year 1997 by Mr. Rafi Raza. This book is called Zulfiqar Ali Bhutto and Pakistan.
Mr. Makhdoom Ali Khan, we want to hear you.
My lord, yes, I'm just pointing out one thing in
No,
this
but
book.
that is what is the
No, not his opinion.
Ji.
In this book, and that will be probably your lordship will see it in the context also of the video disc which your lordship is now going to view, is a letter, signed letter, which he has put as an appendix B to this book, which was given to him by Mr. Sayyid Sharifuddin Pirzada, who was the Attorney General of that time.
What's the title of the book?
The title of the book is Zulfiqar Ali Bhutto and Pakistan, 1967 to 77. This was a book published by Oxford University Press in 1997. And Appendix B to this book at page 390-391.
Has someone filed it?
यही देंगे ना
आपने फाइल किया हुआ है ये? You filed it at what page?
72.
हाँ?
CMA 59 of 2024.
हाँ, page? हाँ, ये page
Page
77.
72, my lord. Page 72.
Which is the CMA?
CMA 59, my lord.
ये तो title है. Mr. Makhdoom Khan, is this the one? देख लीजिए.
Yes, my lord, the title is the same.
And it goes right up to from 72 onwards, my lord.
75. Actual letter कहाँ है?
Up till the relevant portions are attached from page 72 to 77.
Relevant letter कहाँ है?
ये लगा हुआ है. 75.
The letter is at page 77 of this.
Can you read it then? If
My
you
lord,
want to,
yes.
If you want to read it.
On 24th March 1979, The Supreme Court, while dismissing the review petition of Mr. Z.A. Bhutto, observed that on 24th March 1979, the Supreme Court, while dismissing the review petition of Mr. Z.A. Bhutto, observed that grounds urged by the counsel for the appellant for mitigation of the death sentence were relevant for consideration by the executive authorities in the exercise of their prerogative of clemency. On 26 March, Justice Safdar Shah told media correspondents that the observations of the Supreme Court could not be disregarded by the executive while deciding the question of implementing the death sentence. On or about 27th March, Justice Maulvi Mushtaq conveyed to me that he happened to meet General Iqbal at a reception who was inclined to accept the version of Justice Safdar Shah. Maulvi Sahab desired to have my views. To my query about the confessing accused, Maulvi Sahib disclosed that he had indeed recently learned that Arshad Iqbal, Rana Iftikhar Ahmad and Ghulam Mustafa were assured by the authorities that they would not be hanged, and during the hearing of the appeal in the Supreme Court, the relatives of Mia Muhammad Abbas obtained similar assurances through General Chishti. I commented that in the circumstances the confessions were not voluntary and that would affect the validity of conviction, and in any case the recommendation of the Supreme Court was entitled to great weight. Maulvi Sahib said that he would apprise General Zia about my views. In the evening,
please stop and just tell us who these people are? Who is Arshad Iqbal, Rana Iftikhar?
My lord, these,
one at a time. Who is Arshad Iqbal?
my lord, Arshad Iqbal, Rana Iftikhar Ahmad and Ghulam Mustafa were the witnesses which were used.
Prosecution witness.
They were from FSF, if I remember correctly. They were prosecution
They were
witnesses.
all confessing accused.
Yes, they all confessed.
Confessing accused.
Yes.
All three of them.
What are they called, those witnesses who can support the prosecution side?
Well, those witnesses.
Approvers?
There were two approvers, my
There were
lord.
two approvers.
Who are the two approvers?
Masood Mahmood and Ghulam Hussain.
ये दो अलग.
नहीं, ये उनमें से नहीं है.
These are PWs.
ये वो दो मुल्जिम हैं, इफ्तिखार और अरशद.
Nee, but अच्छा, okay, let's continue reading now. I've understood this.
They were.
And who's Mia Muhammad Abbas?
Mia Abbas was also one of the accused, and he confessed and later on he retracted.
Is PW, DW, approver, what?
He was an accused.
He's a co-accused.
Yes, he's a co.
What happened to him?
He is also hung, my lord.
And the other three,
Arshad, all three of them were hanged.
They all four were executed.
Okay, chale. Please continue now, I've understood.
Were assured by the authorities that they would not be hanged, and during the hearing of the appeal in the Supreme Court, the relatives of Mia Muhammad Abbas obtained similar assurances through General Chishti. I commented that in the circumstances, the confessions were not voluntary and that would affect the validity of conviction. In any case, the recommendation of the Supreme Court was entitled to great weight. Maulvi Sahib said that he would apprise General Zia about my views. In the evening, General Zia...
Who's Maulvi Sahib?
Maulvi Mushtaq Hussain, sir, the learned Chief Justice of the High Court at that time, who presided over the trial. In the evening, General Zia phoned me and said that Maulvi Sahib had briefed him and indicated that Supreme Court was likely to issue a clarification. Then in a cordial way, General Zia conveyed that arrangements had been made in the New York hospital for my bypass surgery and that appointment had been fixed with Dr. Rosenfeld on 2nd April. I reminded the General that the doctors had advised me to have the operation in February 1979, but he had asked me to postpone it till the last week of April. General Zia said all arrangements had now been finalized and I should leave as soon as possible. He wished me well. On 29th March 1979, in a press release issued by the Supreme Court, it was stated that whatever Mr. Justice Safdar Shah had said reflected his personal views only, and he had no authority to speak on behalf of other members of the bench. I left for New York on 30th March and underwent bypass surgery. In the meantime, the Law Ministry and the Law Minister, Mr. A.K. Brohi, in their opinion on the summary to the President, observed, Allah the Almighty has clearly provided as to how the murderer is to be dealt with. He does not permit of mercy to a merciless by the judge or the president. The authority that allows merciful commutation of a sentence is merciless of the deceased, his heirs and his relatives. Mercy, remission or commutation is negation of justice, and justice is not only to be done to the killer who is surviving because of legal formalities, but also to be done to the deceased who cannot be heard but whose soul looks for justice. The revenge, death for death, and that in fact is the humanitarian consideration. On 1st April 1979, the President rejected the mercy petition, and Mr. Bhutto was hanged on 4th April 1979.
Now, two questions. First of all, on this date, what was Mr. Sayyid Sharifuddin Pirzada?
On the dates mentioned in the letter, my lord?
On the date 13/6/95.
On 13/6/95, insofar as I recall, he was in private practice.
And the events, when he mentioned the events, what was he then?
My lord, he was the Attorney General for Pakistan at that time.
He was Attorney General.
Mr. A.K. Brohi was the Law Minister. Mr. Sayyid Sharifuddin Pirzada was the Attorney General.
Now, this mercy petition, I don't get it. Who is he to write a mercy petition?
My lord, he did not. It was the mercy petition submitted in the case of Mr. Zulfiqar Ali Bhutto.
Who submitted it?
My lord, his sister, insofar as I recall, made a mercy petition. He personally did not make a mercy petition.
So, who is Mr. Sharifuddin Pirzada writing after 6 years too? Or
My lord, this-
95, kind of 80, 90, after 16 years?
Yes, he is writing in response to a question asked by Mr. Sayyid Rafi Raza, who was conducting interviews for this book. Mr. Sharifuddin gave him this signed.
What is the worth of this document?
My lord, only to set the background, nothing else.
Nahin to khair chale, it's neither here nor there. It took 16 years for him to write this thing letter.
It's in similar vein. It is in similar
But
vein.
there, the author judge had said something, so it has direct nexus.
Yes,
but
my
this piece of paper, what is it? Show.
Mercy petition was filed by Begum Bhutto.
Yes, there were two
If you
petitions.
don't mind, please have a seat. We are hearing amicus, and we will let amicus finish. You can have your say. Please make the old-fashioned way of proceeding was make a point. If you don't agree with anything the amicus says, we'll hear you at your time. Otherwise, we won't make any progress. Tashreef rakhein Kasuri sahab.
There were a number of mercy petitions, insofar as I am aware.
No, what is the worth of this piece of paper?
My lord,
16 years after the event, you write, what does it mean? I don't know.
it's probably setting the record straight.
What record?
That when asked by the author of this book in the context of how the sentence was
Still, it
executed,
doesn't change anything.
it doesn't, because it's much after the execution.
Let's forget this. Let's proceed.
So, I was only drawing your lordship's attention that this is probably the only other piece of writing, or you may say, which is on the record of one of the persons involved.
Pirzada's conscience did not prick him for 16 years.
And my lord, your lordship also has that video testimony, which will show.
देखिए ना, ये तो अजीब बातें हो जाएंगी ना. We're going to realm completely sort of.
It only shows that he was pointing out that.
If we accept that this has even been written by him, first of all,
Yes.
then why does he take 16 years to write it? So these are too many ifs and
The
buts here.
authenticity of this has recently been confirmed in an article written by Mr. Waqar Rana, who had worked with Mr. Pirzada.
You have worked with Mr.
Yes, I have.
Sharifuddin Pirzada.
Yes, my lord.
Did he own up to this thing?
My lord, I am not aware of this. I am not aware of this.
Chalen, let's proceed.
So,
आगे बढ़ें.
my lord, yes. My lord, my submission before your lordship is that the 4 questions as framed by your lordship are already on the record. That was a differently constituted bench, but they are part of the order of 12th of December 2023 as well, where your lordships identify these questions. On page 3 of your lordship's order. Your lordship says, paragraph 6, the first and foremost constitutional and legal points, in addition to those recorded in order dated 21st April 2011 that require consideration are whether the presidential reference is maintainable under Article 186 of the Constitution, whether the presidential reference requires a factual inquiry, and if so, whether under Article 186 of the
आप बताएं ना, अपना बताएं ना, we know what we've written.
My Lord, yes. My Lord, my respectful submission before your Lordship is that Mr. Zulfikar Ali Bhutto was convicted and sentenced to death in view of the judgment of the Supreme Court in PLD 1979, Supreme Court 38. This, my Lord, my submission is that is not to be treated as an ordinary criminal case, because, as I said, it is one of those rarest of rare cases in common law jurisprudence where the sentence having been carried out as a result of a 4-3 conviction, one of the judges in majority thereafter gave a press interview saying that the judgment was obtained under pressure. If that was the case, the principle of nemo iudex in terms of natural justice comes in, and there are two situations in which your lordships have said which will unravel any judgment of any court. One is that of fraud, and the other is bias. So if
You applying 12.2 principles?
I am not applying 12.2, I am applying the nemo iudex principle. That if a person is affected by any consideration except the due process of law and the facts before the case, then the principle of nemo iudex comes in. This honorable court has...
Now we are going into the merits. We wanted you to attend to the constitutional
My Lord,
of the land first.
This is the constitutional...
This is maintainability.
This is the constitutional submission is based on Article 4 of the Constitution, which I say incorporates the principles of nemo iudex.
Can we read Article?
Yes, my Lord. To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. In particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. No person shall be prevented from or be hindered in doing that which is not prohibited by law, and no person shall be compelled to do that which the law does not require him to do. I particularly emphasize, my Lord, paragraph 1, the first paragraph, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. And second, in particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. And where therefore any other consideration except due process infects a judgment that, with great respect, cannot be sustained under Article 4 of the Constitution.
Why are you not adding Article 9 also?
My Lord, my Lord, your Lordship is absolutely right. May I point out why I haven't referred to it straight away, and I would refer to 10A, but that came later.
10A wasn't there then.
There is reason. If your Lordship looks at the language of paragraph 1 of Article 4, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen. The Constitution recognizes that this is a right which even precedes the Constitution. This is a right which is not being conferred upon by the Constitution. This is an inalienable right of every citizen. Contrast that, my lord, with the language of Article 8, Paragraph 1, which is the Fundamental Rights chapter, and that straight away leads us to Article 9. Any law or custom or usage having the force of law, it talks about shall, so far as inconsistent with the rights conferred by this chapter, shall to the extent of such inconsistency be void. Your Lordship will see the language insofar as it is inconsistent with the rights conferred by this chapter. So over here, your Lordship have rights which are conferred by Article 8 and the chapter on fundamental rights of the Constitution. Your Lordship may see paragraph 2.
You are saying Article 4 rights are inalienable rights, and Article 10 rights, which are the fundamental rights, are conferred rights.
And
so the inalienable rights take preeminence over conferred rights.
My lord.
Correct?
Correct, my lord. And I say that, my lord, the word conferred is used in paragraph 2 as well. And your Lordship will see there too,
G.
they talk about, and as your Lordship is well aware, that these rights, the fundamental rights, can be suspended under the emergency provisions of the Constitution when an emergency is invoked. And at the time,
Which is that provision?
my lord, the emergency provisions are Article 232 onwards, but if your Lordship is looking for
particular provision.
Article 233, paragraph 1, where certain rights are suspended the moment a proclamation of emergency is made. Nothing contained in Articles 15, 16, 17, 18, 19, and 24 shall, while a proclamation of emergency is enforced, restrict the power of the state as defined in Article 7 to make any law or take any executive action, so on and so forth, my lord. And if your Lordship then turns to paragraph 2, while a proclamation of emergency is enforced, the President may by order declare that the right to move any court for the enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2 as may be specified in the order, and any proceeding in any court which is for the enforcement or involves the determination of any question as to the infringement of any of the rights so specified shall remain suspended for the period during which the proclamation is enforced, and any such order may be made in respect of the whole or any part of Pakistan.
Sub-Article 2 only deals with 15, 16, 17, or it encompasses all the
My
fundamental?
lord, it encompasses all the fundamental rights, because over here, the President may by order declare that the right to move any court for enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2.
Was an order in the field when the trial and the appeal took place?
Yes, my lord.
Which is that order?
My lord, after 5th July 1977, when the proclamation of emergency was made, the Constitution was put in abeyance.
Where can we read that?
My lord, I will find it in a moment and place it before you.
PLD 77.
PLD 77.
आपने कहा ना proclamation of emergency क्या था?
जी sir. और
77 में होगा PLD.
So for one no
Federal statutes.
So for one, no order has to be made. Under paragraph 1, no order has to be made. It happens automatically by the operation of law. By the
One doesn't attend to Article 9.
But under 2, an order has to be made.
Makhdoom, can I take you back a little?
My lord.
I want to understand, what is the question of law that's been placed before us? Is the question of law to revisit a judgment of this court? Or is the question of law that the judgment has to be revisited for two reasons, because one of the judge made a statement, or because the country was passing through a period of deviation? And would that not entail, is that the question of law?
No, my lord. The
What's
second
question of law
second is not the question of law. It's the first which is the question of law. And my submission, based on that first question of law, that Article 4 of the Constitution never having been suspended, and Article 4 of the Constitution, as this Honorable Court notices in the case of Ghulam Mustafa Khar, PLD 1989, Supreme Court, page 26. This was actually even made a part of the PCO, so even the military regime of that time continued with this article and observed that all these requirements will be observed, that in view of that, any order which has been passed in violation of the due process of law can be revisited by this Honorable
Violation, you
Court.
say, is because of that interview.
Because of that interview,
Would that not then require a further inquiry into a factual situation as to what the interview was, what did he say, what would the pressure really mean? Are we also supposed, and I want to understand this, that 186 is a question of law, we just answer the question of law as the question of law is? Or are we to investigate further that what is the reason for that question of law, that being an interview according to you? Could we go into the interview? Could we then call people, find out what, could we get into this phase of inquiry to answer the question under Article 186, or is it simply a question of law without an inquiry?
my lord, it is a question of law that if it comes to light that a particular judgment was a result of considerations other than the due process of law, then that judgment by itself becomes questionable.
But this factum that it was otherwise requires inquiry. We can't just simply look at a video and say this happened. What about the other judges? There are a number of judges on the thing. So, I mean, what I want to legally understand is that when we start addressing a question under 186, is it just a legal question, or this might, as in this case, entail looking at evidence and then also the veracity of that evidence, the interpretation of that evidence? Are we going to entail that, get into that exercise also?
My lord, the immediate response will be based on two
I
judgments.
want to add one more thing. That can you point out any specific question that is being posed to us in the reference that is to be answered? Specific question for the Supreme Court.
My lord, this Honorable Court itself has posed...
No, in reference. In reference.
My lord, the reference is before your lordship.
Then we should be confined to that question.
My lord, no, your lordship has now framed questions, but if your lordship is looking at the reference on pages 16 to 18, the questions were framed at that time. But may I read those in a minute? They're here. But in order to answer my lord, Mr. Sayyid Mansoor Ali Shah's question, my lord, this arose in the context of an appeal before this Honorable Court, so the issue was open at that time, and it arose in a context where the proceedings had finally concluding in the House of Lords, as it then was called, in the United Kingdom. In the Pinochet case, the House of Lords, again by a narrow majority, had come to the conclusion that Mr. Pinochet needs to be extradited. An issue arose, and your lordship knows that ordinarily the House of Lords never reviews its judgments. Once they have given a judgment that's final, concluded, and the proceedings were over. But an application was made that Mr. Justice Hoffman, who was one of the members of the majority, his wife was part of the Amnesty International, and Amnesty International had submitted an amicus brief.
That was a review, was it?
My lord, but your lordship knows that unlike in our case in the
That could
Constitution of
certainly
Pakistan,
happen if we were to decide a matter. Somebody could file a review and say that one of the judges had a... So I want to really understand the jurisdiction under 186, that a question of law, as I understand, is that this judgment is wrong. Fair enough. Can we just look at it can we then revisit the judgment and say it is wrong, or don't we relying on some extra material now, which you say is the interview, which requires inquiry? Could we just take the interview on the face value, or are we to then find out what the text meant, or are we to, some people need to come forward, do we need to cross-examine, do we need to get into all this, or just take the interview on the face value? And that's just one judge. There are a number of other judges who are not saying anything. Maybe they were not under pressure, or they were, we don't know. So my legal question is, are we to dive into an inquiry? Is that envisaged under 186 is my question.
जैसे जरा सा मैं अपनी तरफ से जरा बात करना चाह रहा हूँ। जो अब आपने बातें की हैं आर्टिकल 4 की, जो आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, चाहे 233 के तहत भी नहीं किया जा सकता है। आर्टिकल 9 की एक अलग बहस है, मगर अगर आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, तब ये हम बात क्यों नहीं कर सकते हैं, इस केस को अलग रखें, मगर हर क्रिमिनल केस में जहाँ के प्रोसिक्यूशन में एलिमेंट ऑफ पॉलिटिक्स इन्वॉल्व हो जाए, नेचुरली एक वक्त में जबकि आइन सस्पेंड हुआ है या एब्रोगेट हुआ है, तो हर को क्यों नहीं राइट मिले दोबारा अदालत का रुख करने के लिए कि जी आर्टिकल 4 तो आपने नज़रअंदाज ही कर दिया, तो आपने कहा कि सिर्फ और सिर्फ ये हम इस केस को देख सकते हैं, हम सारे ऐसे केसेस को क्यों ना देखें? ठीक है, वहाँ अगर मगर आर्टिकल 4 को देखने के लिए कि दरवाज़ा खुलता है या नहीं, मेरे हिसाब से आपको केस में जाना पड़ेगा। आप सिर्फ ये कह सकते हैं तो नहीं है कि जी क्योंकि उस ज़माने में माशाअल्लाह लगा हुआ था तो फलां शख्स को फांसी हो गई तो ये अनकॉन्स्टिट्यूशनल हो गया। नहीं, आपको थोड़ा सा और मेहनत करना होगी कि आर्टिकल 4 का तो आपको दरवाज़ा है, मगर आर्टिकल 4 के दरवाजे को खोलने के लिए आपको कुछ हमें बुनियादी चीज़ें दिखाना होंगी। ये ज़रूरी नहीं कि इसी केस में हो, दूसरे केस में भी हो सकता है, मगर वो अब देखेंगे अगर सदर साहब मुनासिब समझें कि वहाँ भी रेफरेंस भेजें, क्योंकि रिव्यू का जुरिसडिक्शन ख़त्म हो गया, तो फैसला तो ख़त्म हो गया हर लिहाज से, अब रह गया सिर्फ ओपिनियन। तो मैं तो कहूँगा कि अगर आपकी बात को हम आगे ले जाएं और लॉजिकल कंक्लूजन पे ले जाएं, तो हर केस में हम कर सकते हैं ये, अगर नंबर 1 वो उस वक्त में कॉन्स्टिट्यूशनल डिपार्चर हो, पहली बात। दूसरी बात ये कि आर्टिकल 4 के आप प्राइमा फेसाई केस आप इस्टेब्लिश कर पाएं। तीसरी बात फिर ये होगी कि ठीक है, आर्टिकल पहली बात भी हो गई, दूसरी बात भी हो गई, मगर हर केस इस बुनियाद पे नहीं ख़त्म हो सकता है, उस पर ओपिनियन नहीं दिया जा सकता है, मगर उसमें आपको कुछ मज़ीद दिखाना होगा, और वो मज़ीद दिखाने के लिए इस केस में एक जज साहब का इंटरव्यू है, दूसरे केस में शायद कुछ और हो सकता है कि वो डीएनए एविडेंस आ गई हो, फॉर इंस्टेंस कि जो ज़माने में डीएनए नहीं होती थी, डीएनए एविडेंस आ गई है। तो ये आप इससे एग्री करेंगे या आप इससे डिसएग्री करेंगे?
My lord, I would most respectfully agree with it, because I would respectfully submit that this is something which is now happening in the other jurisdictions of the world as well. In some cases, it is happening in the context of the state having recognized that in politically charged cases, injustices can take place which need to be corrected, has itself specifically conferred this authority on the courts of law.
That's fair enough. I mean, I'm for fixing miscarriages of justice whenever they happen. It's happened outside another jurisdiction. Miscarriage of justice needs to be fixed. There's no doubt about that. My question right now is the jurisdiction this court enjoys to do that. You know, to understand that. The review is done with, so we don't have any judicial remedy available. So just want to understand whether the window 186 provides is there to fix a miscarriage of justice through an opinion. Is that possible? Because that miscarriage of justice requires probing into the matter, which could be, I mean, you could argue that 186 does include probing into the matter. So that, I want to understand the window, the door that is to be used for the purpose of fixing miscarriage of justice.
If I may just add to my learned brother's thing, I don't think even if we were to come up with a different opinion, there is no question of fixing anything. Now it is only a question of posterity and history. You can't fix anything because the sentence has been carried out. So you can't possibly fix it. So at the moment, all we are faced with is, do you want, as it has been said, do you want this to be used as a precedent in the future? Probably we can give an opinion on that. We can say yes, no, or whatever else we may hear. So fixing part is over. I mean, if the person was alive, that would have been a different scenario. So that scenario is not before us anymore. So even if we were to come to the conclusion that this was miscarriage of justice, we cannot fix it. So the judgment has come, the review has come, that's over. Now we are more concerned with the repute of a person, posterity, history, and whether it constitutes a good precedent for courts to apply. I think probably we can restrict ourselves, and that's the only thing we can really do.
My Lord,
Mr. Makhdoom, let me add to that also, because there's another question that arises in this.
My Lord.
The sole plank on which this case rests is that at that time the judiciary was not independent. It was under pressure. This is the sole plank. There is no other argument. The argument is you could establish that the judiciary was not independent, this judgment goes. Now, how do we go about establishing that fact? And the exercise involved in establishing that fact requires inquiry into the matter, because there is no other argument. The only argument, Article 4 is violated because judges at that time were not independent, allegedly, as said. So how do we entail this? How do you get into this exercise that the bench was not independent?
My Lord, may I?
Let us not generalize the issue of judiciary being not independent at that time. There were honorable judges sitting at the bench at that time. There, the issue is only restricted to one judge who then came out and he made a statement. So let's not generalize and
If that is the case, that if it's only one judge, then the question is, how does that matter if the rest of the judges we have know nothing on? So how many judges are we talking about? If one judge went astray, then what
I think one judge would.
That too requires some inquiry, whether to all this pressure, what does it really mean by this pressure?
Khan Sahab, देखिए, if it was unanimous court or a larger court, one judge would not matter. But if it is the judgment of acquittal and conviction stood on one judge, then I think one judge would matter. And this does not suggest that the other judges were not independent. Let's assume they were all independent, but one judge has categorically come forward and said something. Now, we don't need to enter into the realm of was this actually in an interview, because long after the interview came, broadcast on public national television, he could have said, this interview is doctored, this is not my interview, this is not me, my picture was put, or whatever. That has not happened. And he survived a great number of years after that. So one judge, I think, does matter in this case. There may be other cases, okay, you'll say, okay, one more vote goes out, what difference it would make? Nothing. But here it hung by a thread of one vote. It did matter, I think. That's, if it was 4, it would have gone the other way, acquittal, as simple as that. I can't see any other result.
My Lord, there have been a number of questions by your Lordships. May I?
We at this juncture see the thing now, because
Yes,
I believe it's ready, or you want to continue with your thought?
My Lord, no, I'll answer your Lordship's questions. I have noted them all down. After that, if your Lordship so pleases. Or now, as your Lordship pleases.
लगा दें? वो बड़ी स्क्रीन पे नहीं लग रहा है? You'll have to make do with the smaller screen. Can you just turn one a bit that way so everybody can see it? We can see the one and you can volume दे दें.
काफी बड़ा इंटरव्यू सर।
इसको पैदा हुए चीफ जस्टिस सुप्रीम कोर्ट ऑफ पाकिस्तान 26 अप्रैल 1993 को हुए और 14 अप्रैल 1994 को रिटायर हुए। अप्रैल का महीना डॉक्टर साहब की जिंदगी में बड़ी अहमियत का शामिल है। डॉक्टर साहब से हम गुफ्तगू करते हैं।
और तेज हो सकता है
कि हाई कोर्ट के बैरूनी जो दीवार है, लोग उसके साथ गुजरते हुए भी बड़े एहतियात से गुजरते थे कि अंदर जज बैठे हैं, अंदर बड़े लोग बैठे हैं, वो लोग बैठे हैं जो बड़े फैसले करने वाले हैं। और आज उसी बिल्डिंग में गेट से एक आदमी मोटरसाइकिल पे दाखिल होता है, हॉर्न बजाता हुआ दूसरे गेट से निकल जाता है। तो ये जो सूरत हाल पैदा हुई, ये क्या है?
یہ تو میرے خیال میں آج کل کا زمانہ ہے جس میں کوئی کسی کی بھی زیادہ رسپیکٹ نہیں ہے. باقی جج تو وہی ہیں بیچارے, اسی طرح محنت کر رہے ہیں, اسی طرح ایمانداری سے ہی کام کرتے ہیں, لیکن لوگوں کو ان کے بارے میں کچھ شبہات ہیں, شکوک ہیں, حالانکہ میرے خیال میں جسٹیفائڈ نہیں ہے. تو باقی یہ جو آپ کہتے ہیں کہ وہ احترام اتنا نہیں رہا, یہ تو میرے خیال میں یہ سوسائٹی میں سارے محکموں میں, سارے اداروں میں, ہر جگہ بس لوگ جو ہیں وہ بہت ہی مادر پدر آزاد ہو گئے ہیں.
لوگوں کا یہ خیال کیوں ہو گیا ہے کہ ان کو انصاف نہیں مل رہا؟ کسی سطح پر لوگوں کو اگر انصاف نہیں ملنے کا یہ تاثر ہے تو کیا اس تاثر کو ختم کرنا جوڈیشری کا کام نہیں؟
یہاں کام تو جوڈیشری کا ہے, مگر وہ مجھے سمجھ نہیں آتا کیسے کریں. ایمانداری سے کام کر رہے ہیں, محنت سے کام کر رہے ہیں, صحیح کام کر رہے ہیں, تو پھر بھی تاثر رہتا ہے. یہ زیادہ سیاسی مقدمات کی وجہ سے ہے. جب وہ کوئی ایسا کیس آ جاتا ہے جس میں گورنمنٹ انوالو ہوتی ہے, یا اسمبلی کو توڑ دی جاتی ہے, یا کوئی پرائم منسٹر کے خلاف کوئی ایکشن ہوتا ہے, تو وہ ان معاملات میں شاید جوڈیشری نے اتنی تنہی اور اتنی انڈیپینڈنس سے شاید کام نہیں لیا جتنا کہ لوگوں کی توقعات تھی. اس کی وجہ سے یہ میرے خیال میں یہ زیادہ امپریشن ہوا ہے.
شاہ صاحب, یہ کتنی, کیا آپ اس کو افسوسناک بات نہیں سمجھتے کہ لوگ کہتے ہیں کہ وکیل کی بجائے جج کر لیا جائے؟
نہیں, یہ تو لوگ تو کہتے ہیں, مگر میرے خیال میں یہ زیادتی ہے اور یہ بالکل غلط بات ہے. ججز ابھی بھی محنت سے کام کر رہے ہیں, ابھی بھی وہ بالکل صحیح فیصلے کرنے کی کوشش کرتے ہیں. اب لوگوں کو تو کوئی روک نہیں سکتا, کیونکہ لوگ آج کل بہت ہی, جیسے میں نے کہا, مادر پدر آزاد ہوئے ہیں. ہر ایک چاہتا ہے کہ فیصلہ اسی کے حق میں ہو. اگر اس کے حق میں نہ ہو, وہ سمجھتا ہے کہ جج دوسری طرف ملا ہوا ہے.
عوام سے آپ کیا کہنا پسند کریں گے یہاں پہ کہ وہ کیسے, ان کا اعتماد کیسے بحال ہو؟ یہ صرف سیاسی فیصلوں کی بات نہیں ہے. لوگوں کو جب لٹیگیشن میں جانا پڑتا ہے, جب لوگ کسی ظلم کے خلاف, کسی ناانصافی کے خلاف, کسی غیر قانونی چیز کے خلاف عدالت میں, کسی بھی عدالت میں جاتے ہیں, اور وہاں پہ وہ اگر پٹیشن دائر کرتے ہیں, تو انصاف اس حد تک دیر سے ملتا ہے کہ انصاف کا مقصد ہی ختم ہو جاتا ہے.
یہ تو ہم نے دو باتیں کی. ایک کو ڈیلیز کی بات کی کہ اتنا تاخیر سے ملتا ہے کہ وہ جو ہے اس کا مقصد ہی فوت ہو جاتا ہے. اس میں تو اور عوامل ہیں, مگر یہ کہ ان ججز جو ہے ایمانداری سے کام نہیں کرتے, یہ ایک دوسری بات ہے. میں سمجھتا ہوں کہ یہ جو ڈیلیز ہو رہی ہے وہ اس لیے ہے کہ ججز کم ہیں, کام بے شمار ہے. آپ دیکھیں گے ہر ایک ہائی کورٹ کے جج کے پاس تقریباً 40 مقدمے روز ہوتے ہیں. اگر آپ کسی یورپین کنٹری میں جائیں تو 40 مقدمے وہ سارے مہینے میں نہیں طے کرتے.
کس نے روکا ہے کہ ججز نہ زیادہ رکھیں؟ مطلب کوئی ایسی پابندی ہے کہ ججز زیادہ نہ رکھے جائیں؟
نہیں, میرے خیال میں وہ حالات ہیں نا, یعنی کہ جج کی
ریلیونٹ وہاں سے بتا سکیں گے,
یعنی کافی تنخواہیں بھی کافی ہیں.
وہ منٹس آپ کو پتہ ہے کہاں سے؟ تو بہت ساری باتیں ہو رہی ہیں. ریلیونٹ کتنے دیر بعد آئے گا؟
میں نے آپ سے عرض کیا, جو میں نے فائل کی ہے نا,
یعنی کس نمبر پہ آئے گا کچھ آپ کو پتہ ہے؟ 5 منٹ بعد, 10 منٹ بعد؟
یہ پوری تو میں نے نہیں دیکھی ہوئی. پوری جو ویڈیو جو ابھی جیو نے دی ہے,
ڈیوریشن بتا دیجیے نا آپ کتنے منٹس کے بعد ہے, تو اس کو آگے کر لیتے نا.
جو پورشن آپ کو آپ کے سمجھتے ہیں فیور میں, وہ کب آتا ہے آپ کو پتا ہے یا نہیں؟
اس میں نے جو آپ خود فائل کی ہوئی ہے,
اس کا بتا دیں.
اس میں مشکل ہوگا مجھے بتانا.
آپ کی USB میں ہے؟
جی ہاں, جو میری USB میں ہے, میری USB آپ چلا لینا. وہ
پرٹیکولر USB ہے سر, اس کو لگوا لیں جو ان کی ہے.
اس کے اندر پرٹیکولر جو میں نے USB فائل کی ہوئی,
دے دیں آپ نکال کے دیں. USB
میں نے دی ہوئی ہیں سر. کیا کہتے ہیں
یہ ڈائریکٹ ہو جائے گا نا.
Constitution, law and Pakistan affairs must be placed before this court, and that is a book written by him. He has explained all these matters in details, in writing.
Suri sir, we definitely hear you. Abhi we are just trying
that
to.
book should be placed before all the judges, and
وہ آپ نے بتا دیجیے
page 182 onwards.
آپ نے فائل کی ہوئی ہے؟ جی
आपने फाइल
मैंने एक्सेप्ट लगाए अपने अपने
CMA नंबर
मैंने ये आप देखिए
CMA
मेरा ये
बताइए।
है 5788
एक सेकंड
वो किताब पहले की है या इंटरव्यू पहले का है?
नहीं, किताब का नाम बताएं।
किताब का नाम है जी कॉन्स्टिट्यूशन लॉ एंड पाकिस्तान अफेयर्स रिटन बाय चीफ जस्टिस डॉक्टर सैयद नसीम हसन शाह।
ये इंटरव्यू उनका बात का है या किताब पहले की है कसूरी साहब?
जी
इंटरव्यू बात का है या किताब बात की है? पहले कौन सी चीज आई?
I wish I could give a positive answer, but this is his written statement, and in my
इंटरव्यू की डेट क्या है किसी को पता है?
इसमें अंदाजन आफ्टर 22 मिनट्स जो मैंने अभी
इंटरव्यू की डेट क्या है?
किसी सर
जो चल रहा है इंटरव्यू, ये कब का इंटरव्यू है?
ये जो हमने देखा, ये कब इंटरव्यू लिया गया था?
सर आफ्टर दी एग्जैक्ट डेट सर अभी मुझे
3/12/2003
ये इसमें इसके खत में क्या लिखते हैं?
ये बुक कब पब्लिश हुई है?
ये मेरा जो रिटन रिप्लाई है उसके पेजेस हैं सर 42
नहीं, ये इंटरव्यू
42 से लेके
3/12/2003 का। अच्छा, ये नोट कर लें डेट। ये जो इंटरव्यू है 3/12/2003 का, ठीक है? वो जब वो तैयार हो जाए बताइए। तैयार है? उसी कॉपी क्यों कर रहे हैं? अच्छा ओके। अच्छा, आप कौन सी चीज बता रहे थे कसूरी
ये
साहब?
पेजेस हैं।
नहीं, नंबर बताएं पहले ऊपर। आपका CMA का नंबर क्या है? या
ये मेरा नंबर है जी अपना CMA नंबर
ये निकालिए जरा।
5788 or 2001,
5788/2001,
which I filed before this honorable court on 31st of December 2011.
जब तक वो निकाल रहे हैं हम ये देख लेते हैं।
And the extracts of the book are mentioned in my rejoinder from page 42 to page 57.
इसमें तो नहीं, तो मार्केट 5788 इसमें होगा।
इधर देखिए, इस बंडल में, इसमें तो नहीं है।
My lord will read this.
इसलिए में 5788 की बात कर रहे हैं।
in my rejoinder